Good evening. I'm Susan Drummond, the City of Pasco hearing examiner. Today is Wednesday evening, November 13th, 2019, about 6 p.m. We have 6 items on the agenda. There are 3 special permits, 2 rezones, and an appeal. I think we will hear those items in the order that they are listed on the agenda. I imagine the first 4 matters will go relatively quickly. The appeal might take a little longer. And then I understand the last special permit for the Franklin County Historical Society Museum Annex has been in process for a bit, so is at the end of the agenda. The order of procedure on all of these items, except for the appeal, will be as follows. We'll hear first from the Planning Department. The Planning Department will provide a summary of the proposal. Then the applicant will have an opportunity to present on the proposal. And then we'll open this up for public comment. Anyone who is here from the public who wishes to provide testimony on the proposal may do so. I may have questions throughout the proceeding. Planning Department may have further clarifications. And we'll address appeal procedures once we get to the appeal. I did have an opportunity to visit all of the sites late this evening, so light conditions weren't the best, but I had enough to get some idea of what the individual sites looked at. And staff reports have been prepared for each of the proposals, and I have reviewed those. So are there any questions on procedure at this point? Okay, I think with that, we will go ahead and start first with item A. This is a special permit for fire station number 84, SP 2019-008. Mr. Adams, are you presenting on this?
Yes, I am. Yeah. Thank you, Madam Examiner. The first item is a special permit application for a fire station on Court Street, roughly at the 49 to 50 or 5,000 block of West Court Street. The site is approximately 4.7 acres. This is a property that was purchased by the City of Pasco and recently annexed into the city and assigned a zoning designation of RS1. The fire station will be 16,000 square feet, roughly, sleeping and living areas for employees, apparatus bays, as well as a 4,364 square foot reserve apparatus building proposed. The architect has proposed metal siding with fiber composite board and accent material. One little glitch in the report here is that even though we have explicitly stated that the height proposed is 35 feet, the RS1 zoning does not allow for 35-foot height buildings, and so part of the application would have to include a request for a height variance.
Okay. Actually, I had a question on the zoning because it said in the staff report, I think that it was on the office side. I think when it was annexed, it was, maybe I got this wrong, it was R1 when it was annexed, but then it's now office, or? It
was office when it was, before it was rezoned.
Okay.
It was a county
Okay,
zoning.
So now the zoning is now R1?
RS1.
RS1, okay.
Which is a 10,000 square foot lot minimum for a residential unit. And then I also need to note that public notice was sent to property owners within 300 feet of the proposed site, as well as posted in the Tri-City Herald on October 26th of this year.
Okay, and I guess I'll have the applicant elaborate on you said a variance would be needed under the RS1 zoning to go from 35 to 40 feet for?
No, 35 feet would be the proposed height of the building, and the zoning allows for 25-foot height for residential units.
Okay.
But you can get a greater height by special permit.
Okay.
So it would be included in this proposal.
Okay. Is there anything further on that?
Nope.
I did want to note for the record, as I mentioned earlier, I had reviewed the staff report and the attachments for each of the proposals, and that does include this one. In addition, staff provided me a copy of the fire station distribution and response zone, which is just a one-page map essentially, which is admitted into the record. Okay, at this point, we will open, the applicant to present. Is the applicant here? Okay. Are you from the fire department? Perhaps if you could step forward, that would be helpful.
Sure.
Okay. Good evening. If you could state your name for the record.
Tom Twite, Battalion Chief, City of Pasco Fire Department.
And can you spell your last name for me?
T as in Tom, V as in Victor, EIT.
Okay. And you swear to tell the truth under penalty of perjury under the laws of the state of Washington?
I do.
Thank you. Do you have anything further that you wanted to add to this proposal?
Not to my knowledge. I believe everything's been already turned in. If you have any questions, I hope I can answer them.
Okay. Yeah, I just had a question. So it's on the height limit, you all need to go up to 35 feet with the building. Is that correct?
I believe it was, did you say 40 feet in the information that was turned in?
No, it's 35.
35.
Yeah.
And that's basically the height of the bays.
Mm-hmm. Okay. And is that for both? I'm looking at the site plan here. There's the new fire station, and then there is the reserve apparatus building. How tall is the reserve apparatus building? Does that also require a variance, or is it just the fire station?
I don't actually have blueprints on that building yet.
Okay.
I think if we have to stay at 35 feet, we could probably make it 35 feet. It just depends on the pitch of the drainage.
Okay. All right. And I have some questions on the landscaping and setbacks, but I can hold those for right now. I'll open this up for public comment, and then I may have staff actually address that particular question. So thank you. So at this point, we'll open the matter up for public comment. Is there anyone here from the public who wishes to testify on the proposal? Let the record reflect that there is not anyone here who wishes to provide testimony. I think what I might do on this one is keep the record open for a little bit just to provide some further clarification on the height that is needed and whether it is needed for both of the buildings or just one of them. And then if I wanted some I couldn't tell, the site plan was a little hard to read in terms of verifying kind of the setback and landscaping requirements. If I could have some verification that both the setback requirements for this particular zone, the RS1 zone, and also the landscaping requirements that would be applied to this project if those are met. And it looks like they're probably pretty close, but it was hard to verify for sure based upon the site plan. So if either the planning department or in conjunction with the applicant could sort both those issues, the height and then the setbacks and landscaping, that would be helpful. And the setbacks and landscaping be a little bit different because they're in different sections of the code in terms of how much is needed for the setback versus how much is needed for the landscaping.
The RS1 zone requires a 20-foot setback.
Okay, and that is on all four sides or
Along Court Street.
along? I'm sorry,
Along Court Street,
First Street.
and then
Or
Court,
Street.
C-O-U-R-T,
Okay.
and then 10 feet on the sides,
Okay.
and the rear would be equal to the height of the building.
Okay, and that doesn't change, I guess because it's an RS1 zone, then it wouldn't change based upon the surrounding zone. I know your code
Right.
sections sometimes switch that
That is
up,
correct.
so you have to look into the other sections to determine the actual setback. Okay, so that should be straightforward. And then on the landscaping, I mean, you can answer now if you wish, or we can just keep the record open for that.
Yeah, the landscaping is, for a residential zone, it's 50% live vegetation, the whole front yard.
Okay. And then in terms of how much on the sides, do you have kind of
None required on
Okay.
sides.
on this? Okay, and the rear?
None.
Okay. Okay. All right, we may not need much additional then on the landscaping and the setbacks. I think primarily then we'll keep the record
Right.
open to just clarify on the height what's needed
Right.
there.
And based on the site design, they're going to have plenty of landscaping.
Okay. Yeah, no, it looked like a fair amount of the site was landscaped, so that shouldn't be an issue. It's just a question. I just had a question on whether it was all in the right spot. So I think what we'll do on today's Wednesday, maybe keep the record open through Monday just to have clarification on the height. Does that work for the applicant and for the planning department? Okay. All right. So we'll keep the record open through Monday. And you can provide additional information to address particularly the height requirement, but if there's anything further that you wanted to provide on the questions on landscaping and setbacks, that would be helpful as well. And then after that, I'll issue a final decision that will be out within 10 business days from close of business on Monday. So any other questions on that? Okay. Thank you. We will move now to the next agenda item. This is also a special permit. This is for the applicant is the Jubilee Foundation. This is special permit 2019-009. Mr. Adams, are you presenting on this one as well?
Yep. Okay, this is the proposed structures are 30,000 square foot, 2-story building. It will sit on approximately 2.27 acres of land in the Terra Vita subdivision. This is a vacant piece of property, and the building will house administrative and professional offices, education, and training areas to support the operations and missions of various non-profit organizations that will be housed in the building. They also propose an accessory use multi-purpose assembly room with associated warming kitchens, and then 4 guest suites that would be on the upper floor for visiting guests and dignitaries, I guess. This is another application where a variance for height is going to be required, or requested, I should say, based on the height of the building.
And that's to go to 40 instead of 35 feet, is that?
40 foot.
40 foot, yeah.
And then we got a letter from the Washington Department of Transportation about some transportation issues. I'm not going to go over that. It's just kind of
I took a look at that. It looks like there was a SEPA condition that's requiring a traffic impact analysis, but I guess the question I had on that was the mechanism for addressing any mitigation that would come out of the traffic impact analysis, since I don't think we have it yet.
It would be the SEPA would be the mechanism that we'd use.
Because usually I'd have the traffic impact analysis, and so then the condition would go into the special permit decision. That's certainly one way to do it.
Right.
Another way, and this is a little unusual, but it could be, well, actually there wouldn't be, there's not a DOT approval that's necessary for this to go forward, so that would not be a mechanism. Unless there's language, it seems to me it does seem to me they raised a legitimate concern about the safety there, and there should be some additional analysis on that. I mean, one way would be to craft some language to address that. The other option would be to keep the record open, and maybe the applicant is here and can address that a little bit more. Maybe that's the best way to. Okay. Anything further on this?
No.
Okay. So I think the applicant is in the back. Good evening. If you could state your name for the record.
Sure, it's Roger Bairstow, B as in boy, A-I-R-S-T-O-W.
And you swear to tell the truth under penalty of perjury under the laws of the state of Washington?
I do.
Thank you. So did you have anything further to add? And I did have the question on the transportation impacts.
Yeah, obviously, I think we're far more interested in not keeping the record open at the moment, and maybe trying to craft some language that would be acceptable to all, just to be able to have the traffic impact analysis done in the course of us getting our design work put together, and then coming to some.
Would that, I mean, one option perhaps is that some language is drafted here that sets this up for the whatever the mitigation is to be based upon the technical analysis that will be prepared and as reviewed by the city, and then maybe that the exact condition is imposed perhaps with the building permit. That might be one mechanism for dealing with that.
Yeah.
I'll ask staff if they have thoughts on that, but that might be one way to.
That would be acceptable.
Okay. All right. Okay, yeah, that was the primary question I had. Thank you.
Thank you.
So at this point, we'll open this up for public comment. Is there anyone here who wishes to provide comment on this proposal? Let the record reflect there is not anyone here who wishes to provide comment. Question for staff on this. Would something work where I put together some kind of condition, or we can keep the record open for a very brief period for staff to propose a condition, but either way, and then the actual mitigation that addresses the DOT concern is imposed at the building permit level? That would be one way to address this.
It would, and the WashDOT was fully aware that one of the viable options for the applicant was to provide a traffic impact analysis. And I believe we would just add language to the proposed approval condition that would state that the traffic analysis would be reviewed by our engineering staff, and then the recommendations provided through the analysis would be implemented as a condition of the building permit.
Okay. Yeah, so I think something along those lines would help address that concern. There's a valid safety concern. It sounded like that should be addressed. So.
And if you're amenable to this, Ms. Drummond, we would suggest that the record be open through Friday, and we will develop that condition and submit it to you for consideration in your decision.
Okay. Does the applicant have any comment on keeping the record open through Friday to have, for purposes of having some language proposed along those lines? Okay. It sounds like there's, just for the record, there's no objection from the applicant to that. So we'll keep the record open through Friday, and then as with the last special permit, decision from me will be out within 10 business days of close of business on Friday. Any procedural questions from anyone? Okay, thank you. That item is closed. We'll now move to one of the rezones. This is a proposal that's on East Alvena Street, a proposed rezone from R1 to R3. This is matter number Z 2019-011.
This is proposal is for 2 lots. You can see them on the map. They're at the corner of East Alvena Street and North Franklin Avenue. The whole area is kind of vacant, and it's been this way for, well, forever, since 1913, since it was platted as the A.M. Weehee White House Edition. There were some residential units on the lot, and they've been cleaned off the lot. Applicant wishes to rezone this from R1 to R3, which would increase the density as per the comprehensive plan that encourages increased density to allow more population within the urban growth boundary and to reduce urban sprawl. The lot is approximately 1/4 acre, or the 2 lots combined comprise approximately 1/4 acre. And that's all the major information, I think.
Okay, thank you. Is the applicant here for this proposal? Okay, let the record reflect the applicant is not here. We'll open this up for public comment. Is there anyone here from the public who wishes to provide testimony? Let the record reflect there's not anyone here from the public who wishes to provide testimony. I did not have any specific questions on this. On a rezone, I issue a recommendation. It's the city council which makes the final decision. The time period for issuing a recommendation is the same, 10 business days. Anything further from staff on this? Okay, my recommendation will be out within 10 business days of today. We'll move on to the next agenda item that is also a rezone. This is at 2216 Henry Place. It's a rezone request from R2 to R3.
Okay, on this proposal, the applicant wishes to rezone the property from R2 to R3, which is a slight increase in density. This used to be a 4-plex, and it was because of the zoning, it was a legal non-conforming use. And when it burned down, they had a year within which to rebuild or lose that legal nonconformity. It was extinguished. And so in order for them to rebuild the fourplex, they'd have to increase the zoning. Staff is okay with that, particularly because it is surrounded by nearly identical units as the one that was there previously. And so it would be in character with the neighborhood. I think that kind of sums it up for that
Okay.
one.
I did not have any questions on this one either. Is the applicant here for this proposal? Let the record reflect the applicant is not here. We'll open this up for public comment. Is there anyone here from the public who wishes to provide testimony? Let the record reflect there is not anyone here who wishes to provide testimony. So this also is a rezone, and I request and I issue a recommendation on those. My recommendation will be out within 10 business days. City Council makes the final decision. Any procedural questions? Anything further from staff? Okay, that agenda item is completed. I think at this point we can move to the appeal. This was, I believe, filed by Tasha Swafford and Ryan McClellan. This has to do, it's a road access question. It's appeal number APPL 2019-002. The procedures on this will be a little bit different. Typically, I'd have the appellant present their case first, and then that would be followed by the city. And if either party wishes to call witnesses, they may do so. I don't know about the approximate length of what the parties were expecting in terms of case presentation. Sometimes appeals can take a bit longer. So, are the appellants here?
Yes.
Okay.
Madam Examiner, good evening. My name is Mark Fickus, F as in Frank, I-C-K-E-S. I'm a partner in the Halverson Northwest Law Firm from Yakima. Pleasure to be here tonight. I'm here on behalf of the appellant, Tasha Swafford and Ryan McMullen. I'm here to present an argument. I assume this is an open record appeal. I don't think it'll take a ton of time, but since this is the only opportunity to create a record, I do have with me today Tasha and Ryan and their surveyor, Mr. Dave Ballman, who is familiar with the short plat and who has been helping the applicant process that. As a preliminary matter, I assume that you've received a copy of the legal memorandum I filed on behalf of the
so
appellant?
I probably should go through what I have before me.
That would be great.
Yeah, so the parties are aware. So there's a short, less than a page staff memo that I have, and that attaches several exhibits. There's Exhibit 1, which is this short plat. And I assume the short plat was approved. Is that?
Well, conditionally, yes.
Conditionally, okay. So with the conditions that are outlined in the materials I receive, I assume, including this question about how to construct the access to it. Okay, it was a little unclear from the record exactly whether it was we had a final decision on that.
Yeah, we a little bit unusual. I think we're appealing an interim decision on a condition before formal findings and conclusions have been made. I noticed that Darcy or Rick White, the planning director, has submitted as Exhibit 6 proposed findings and conclusions.
Yeah.
I don't think they were adopted yet. So the legal issue before the examiner tonight is the legality of primarily of the road dedication and building condition.
Okay.
So.
Yeah, because usually it would be a final decision. So it's a little bit different.
The city took my client's appeal money and recited that the examiner has jurisdiction. I think the examiner does have jurisdiction to hear.
Oh, yeah, that was my
appeals
question.
from
I wanted to
conditions.
I wanted to see if there were any objections to my jurisdiction. Before that was one of the questions I had. Anyway, we might come back to that. But to go through the rest of the exhibits, we've got Exhibit 2, and this has, I believe, what are the conditions or proposed conditions, from the various departments of the city. We've got Exhibit 3. This is a letter from David Bowman, which is the applicant's surveyor, that outlines the concerns of the appellant. Then there's Exhibit 4, which is the city response. Exhibit 5, and I believe that's the appeal. Is that the letter of appeal? It's an October 13th, 2019 letter, and it's from Tasha Swafford and Ryan McMullen. Mm-hmm. And am I correct on that? That's the appeal.
That is correct.
Okay. And then Exhibit 6 is the short plat findings of fact, which sounds like are pretty much final. But and then this is the legal memo that I had received, signed by Mark Fickies, and attaches ABC, I think exhibits A, B, C. Was that? Yeah. And I had a question on this too, because the plat shape is a little irregular on Exhibit A, and it differs from what the city has as the plat on their Exhibit 1. So you don't have to address it right now, but
I think the surveyor, Mr. Ballman, could address that. I think there's been some minor modifications to meet city requirements regarding lot size. So there's been a few minor modifications, and in fact, with Your Honor's permission, I have one other demonstrative exhibit that I'd like submitted as part of the record. This is a short plat map, again, prepared by Dave Ballman and Rogers Surveying, that shows what the proposed, if we had to build and dedicate the road, how it looks like if the applicant were forced to comply with the.
There we go. That's a copy of this for the.
Condition. Yes, that's a copy of the same exhibit, so that can be marked as what, exhibit number 7, or as my legal memorandum could be exhibit 7.
Let's see. Yeah, we'll put the legal as 7, and then this map will be 8. And are there any objections from the planning department to this proposed exhibit?
No.
Okay, it's admitted.
Again, this is basically the same short plat map, just with in the event the additional right-of-way for Castle Holly Court had to be dedicated. Just again, for Your Honor's review and to show what it would look like.
Okay, thank you. So I think I went through everything. I'm not missing anything, correct? Okay. You may proceed then.
Okay. Again, Your Honor, we're appealing. The primary issue is simply the legality of a requirement that Castle Holly Court be both dedicated and built. I appreciate the planning staff's diligence. This is a hard one sometimes for non-attorneys. I know Pasco doesn't have a in-house legal attorney, and I guess Mr. Ferguson, I usually would deal with Mr. Kerr, but I think he retired. But as you can appreciate, in a land use application, an applicant cannot be forced to dedicate land and build infrastructure improvements if they don't meet the constitutionality test of the U.S. Supreme Court and a long line of Washington case law. And really simply, it requires every condition to give away land has to be, the need for it has to be directly caused by the application at hand. The condition has to solve the problem, and it has to be proportional. I won't bore you. It's on page 4 of my legal memorandum.
Yeah.
It's for attorneys.
I did review your memo, and I've read those cases. I'm familiar with the cases.
Okay, good. I mean, these are issues that come up all over jurisdictions in Washington. It's my most common legal issue that's raised in land use applications. And this one's really easy and simple. In fact, if you look at it, the Castle Holly Court, the cul-de-sac, these 2 lots would not use it at all. I get why the city wants it in the public interest. They obviously had planned that at some point in the future, this property would build the other half. But both of these lots already have direct access to Road 56, which has 60 feet of right-of-way. It's operating at a sufficient level of service. There's absolutely no evidence in this record that the trips per day caused by one additional lot, one additional house, would trigger the need for a separate road. In fact, the applicant's proposed to access both lots from a private driveway directly off Road 56. You can't see it there, but it's of the northern portion of Lot 2. So in this case, neither lot would ever use Castle Holly Court, which it would only be used by the owners. If you look at the southern portion of the map, you can see the 4-lot short plat that's currently using Castle Holly Court. So in this case, again, you know, I've been doing this for 33 years, and this is one of the clearest cases of an exaction that's illegal right now and premature. If we were coming in with a 4-lot short plat that needed additional access that would use it, it would be a closer call. But in this case, you know, it simply can't withstand the constitutional test of Nolan Dolan, the 4 cases I've cited in Washington, and the test has even been incorporated. The applicant's surveyor was actually on the ball, and about 5 years ago, Washington subdivision ordinance actually incorporated that says no, and this is in RCW 5817-110 sub 2, that no provision for public improvements or roads shall be allowed if it constitutes an unconstitutional taking of private property. Of course, the hard thing, they didn't give any, you know, help to city planning staff on how to interpret that. But again, in this case, you know, it's real clear that this would be an illegal exaction.
I had two, sorry.
Yeah, go ahead.
I had 2 questions. One is I did visit the site tonight as I visited the other properties, and there's an existing driveway. Is that how access would be provided, is through the existing driveway? Is that what's proposed by the appellant?
What's
Okay.
proposed is they utilize the existing driveway, or actually there's enough room, there may be 2 existing driveways, and the applicant's happy to work on if they need road approach permits to Road 56, but both lots would probably have direct access
Through that existing driveway?
Yep, through the existing driveway or a new one built just north of Lot 2.
Okay.
Again, you know, I
And
didn't
then-
check, but I think Castle Holly Court, the half street, is already dedicated as a public street. I mean, that could be an alternate access, but it's not one that's proposed to be used by.
You mean on your client's property?
No,
on
I
the
don't
other
know
side.
whether it's a private roadway. Maybe Rick could tell us, but if it is, that would be an alternate access, but it's not needed. In this case, man, the surveyor and the client developed this short plat specifically to avoid that road development condition. In fact, if you look on how much difficulty, you can see the 30 feet, they'll have to remove a shed, they'll lose their well house, the road would be right next to their home, and there wouldn't be enough property. Not to mention the fact dedicating and building it would be a $20,000 to $30,000 project that would make creating one lot completely uneconomical. And again, my client's here to confirm that. So the bottom line is, you can see on the configuration, they're not going to use it. The applicant's home is right there on Lot 1. You can see it right there on the lot home, and they're creating the frontage lot for purposes of selling and developing it as another single family residence that, again, will have completely adequate access. So in terms of the legal standard, the adequate access to Castle Holly Court is not needed, or the need for it is not created in any way, shape, or form by this application. Again, I think this is one that would be a closer call if Lot 1 gets redeveloped into future lots that need.
Yeah, I had a question about that in terms of, so your client doesn't object if there's further development of Lot 1 to making those
Not at all, although it might not be appropriate to incorporate into the findings of fact conclusion of law. But no, the answer is no. Future development that would need or utilize the road, it might be appropriate at that time. But right now,
So I wouldn't
based on
think
this
it
lot
would,
configuration.
and I'm just, in terms of making sure there's not a preclusive effect, because right now the driveway is proposed for the access, but
That's
then
correct.
if you had future development, it presumably wouldn't make a lot of sense to continue to use that driveway instead to improve that existing.
It depends. It depends on how many lots and how it would be configured in the city's road development standards. But right now, I don't see Castle Holly Court, and the client doesn't see Castle Holly Court is is needed, and there certainly are no development plans in the future.
At present.
And actually, I appreciate the city's, integrity and honesty, and if you look at the reasons they've cited for the letter, they've admitted basically that it's for future development of land in the project's vicinity, and the case law it makes it illegal. You can't require dedications of land and construction of road to benefit neighbors or future development. The need for it has to be created by the application at hand, and it has to be proportional. This one doesn't. You don't even get to proportionality because there's no causative effect. And the city cites to its own ordinance, and I don't think they're inconsistent with not requiring the road. The city has the cites to, I think it's Pasco Municipal Code 2115, continuation of existing streets. Well, that's not applicable. This Road 56 is a continued street, and it's fully built out with 60 feet of right of way, and this is a cul-de-sac, so that doesn't justify it. And then half streets, it says half streets shall be prohibited. I would agree if we were building a half street. We're not. Road 56 is a full street. They want us to finish the half street started by the neighbor, and that's what makes it inappropriate in the present matter. So with that in mind, I'd be happy to answer any questions. I've read Darcy's memo. It doesn't look like the city was necessarily disagreeing with me. They're at a little bit of a disadvantage because Mr. White is not an attorney, and I don't see Eric here. So I'd submit it to the examiner, just like some input that the ultimate findings and conclusions do not require Castle Holly Court to be dedicated and built. Also have some questions about whether sidewalks need to be built, but that wasn't necessarily roped in the appeal. I got involved after the appeal had been filed. Obviously, I didn't have an opportunity to prepare the appeal letter. But so we would, I guess, would request that the examiner make a ruling, findings of fact, conclusions on the legality of that condition, and that the ultimate findings of fact and conclusions proposed by the city be consistent with the examiner's ruling. And I think some of the ones that had to be tightened up would be the required development of standards for the Pasco Municipal Code and the specifications for the city engineering. Obviously, we're here to appeal, so I'd like a little bit more specificity with regard to what will be required in terms of roads and sidewalks consistent with the appeal. So
I'm just limited to what is actually in the appeal. And the focus of this appeal is the road access.
We'll stick to the road then.
Okay.
I'll let the client deal with the sidewalks to nowhere issue on their own.
There was something in the appeal about sewer waiver. Was that more along the lines of comment? It didn't seem like.
I think that's more along the lines of comment. I'll leave it up to my client or the surveyor. I think they understand that they're going to have to get the sewer waiver. This is outside the sewer is not readily available to the property, and there's a waiver process that the city requires in order to maintain an on-site septic system, which is what's proposed.
Okay.
So, yep, the main legal issue is the road, and again, I'd be happy to answer any questions, but I'd like this Mr. Ballman and maybe Tosh to have a brief opportunity to provide comment, and then I don't know if the city has a response or is just going to throw themselves on the mercy of the court in this case.
So I did not swear you in because it was legal argument. I assume that was your intent. Is that correct?
Yes.
Okay.
Yep.
So then you have two your clients. The two appellants are here and they wish to provide testimony.
That is correct.
Okay. So we'll
just to create the record.
Right. So we'll go ahead and go forward with that. Okay. I don't know who you wanted to call first, but
I think the surveyor, Mr. David Ballman of Rogers Surveying, would like to make.
Okay. Good evening.
Good evening.
If you could state your name for the record.
David Ballman, professional land surveyor, certified federal surveyor, and principal of Rogers Surveying, Inc.
And you swear to tell the truth under penalty of perjury under the laws of the state of Washington.
I do.
Thank you.
So I'm also happy to answer any questions you might have regarding the lot shape that you brought up earlier.
Right.
Yes.
Yeah.
When I initially laid out the shapes of these lots, I was misinformed, I believe would be the right word, about the minimum area requirement for septic in this soil type. And so while the city was in the midst of their review, I got a note from the health department that we needed to make that lot 2 slightly bigger. So I was playing around with various sizes and shapes to make that minimum size. Once we got the conditions of approval letter from the city, I stopped all that so as not to wind up wasting my client's money if this wasn't going anywhere. So what will wind up if we do go forward with this is a slightly different lot shape than what you're seeing here, but it's not much different. We only needed a few hundred or a few thousand square feet. I'm confident. I think I have a design that will meet all of that, presuming that we don't have to dedicate 30 feet of road on the south side.
Okay, yeah, and the lot shape, you know, that's not really before me, so,
Sure.
but I was curious as to kind of what the actual layout was. So, do you have anything else that you wanted to add?
Only that I believe it was said in some of the materials there that these lots were specifically designed to front on Road 56. Obviously, we were aware of that half street on the south, but didn't need it for this short plat. My first step whenever someone calls me looking for a short plat is to send them to the planning staff and say, go talk to them, see what you're up against, because I can't predict what all little things are going to come up. That road on the south side, to my knowledge, was never mentioned until we got that approval letter, the conditions of approval letter. So I know they don't always have all the information until they move it about the various departments, but I don't think that's the kind of thing that can be sprung upon someone that late when they've already spent a couple $1,000s with me and application fees and applications to the health department and various other things. Oh, by the way, you're going to have to build a $30,000 or more road that nobody told you about. I think that's a little over the top, but that's obviously my personal opinion. But that is a step that I always tell people to go talk to the planning department first. Again, it was brought up earlier, the well house would wind up within, at least partially within the road right of way. I believe the well itself would be outside the right of way, barely, but obviously they'd have to knock that building down if that's within the right of way and completely reconfigure that. And their other shed would go away completely. And the house would barely meet minimum setback for this zoning off of the road when you consider that side to be the front. So, and I'm happy if you have any other questions.
No, I do not.
All right, thank you.
Thank you. Do we have another witness that you wish to call?
Madam Examiner, I don't think so at this time. I think we've got an adequate record here, and the applicant would prefer not to speak. I just want to point one thing in terms of conclusions and argument. Again, if you read one thing, I'd ask that you read, there's a really recent Washington State Supreme Court case. It's an interesting read. It's the Church of the Divine Earth. And by the way, it's almost factually identical to this case. It's a church that was going to build a parsonage, and the city had road requirements, said, hey, there's only 30 feet of right of way. We need 60. And they just said, made the same citations as Rick and Darcy are making in this case, that it's what our law says. And the court said, no, that doesn't hold water. And they even remanded it to tag him for damage under RCW 6440. I'm not looking at that now. I don't think the city was aware of it, but that case is on all fours.
Yeah.
And it's a good summary of the exaction land use law if you haven't read it before. So.
No, I saw that case. It's pretty recent. Came out fairly recently.
All right. So in conclusion, I just, I take the city its word. General statements of public interest don't support roads that aren't caused by the condition. You can't require roads built for your neighbors or for future development. And in this case, again, I would, on this record with absolutely no information other than general statements, I think this condition can't survive. Thank you.
Thank you. So at this point, we'll turn to the planning department. I did not know how you wish to proceed. It's up to you all to, in terms of presenting your case.
No, Madam Examiner, only to state that we believe that PMC 2115 and 2115-010 are legitimate applications of our subdivision code in this case.
Okay. Yeah, the only question I had, and this I had asked the appellant's counsel as well, is about the potential preclusive effect. You know, if you build an entrance on one side, and then if the lot one is further developed in the future, I don't know what the development potential is on lot one, but that was a question. That was just a question in my mind. I don't know to what extent I need to address it, but I did have that question about the preclusive effect of access on one side. And of course, it's just to the two lots. But were there any concerns at the planning department on that?
Well, I think Mr. Fick has stated accurately that, yes, it is a condition of future precedent. Lot 1 and Lot 2 are certainly not always going to be owned by the people that are in this room tonight. If Lot 1 the owner of Lot 1 intends to further subdivide, there's certainly no guarantee that the future owner of Lot 2 will allow a 30-foot half-street dedication and improvement to occur on their property.
Okay. All right. Anything further from the planning department? No? Okay. Mr. Fickus, is there anything further that you wish to?
Just real briefly, just addressing the last issue.
Yeah.
Okay. On the preclusive effect, I would have not object and would have no problem with the statement that the examiner's ruling does not preclude the city from requesting the dedication and building of additional in the future. And I would prefer that it not be set in stone, because it depends on what development, how many lots are created. But it certainly is not intended that the ruling one way or another would preclude the city from requesting the right-of-way consistent with its ordinance in the future.
Yeah, I just wouldn't want to see kind of a piecemeal sort of thing. Well, one lot here, one lot there, and then all of a sudden, yeah, you kind of get that sort of.
No,
Yeah.
that's not. We're
Okay.
just in. But on this record, on
Right.
this, it's not required.
Okay.
Thank you.
Thank you. So I do not have any further questions. I think I have what I need on this. It is a bit unusual procedurally in some ways, but a decision on this will be out within 10 business days, counting from today. And that will be emailed to the planning department and then will be provided to the parties. Although it looks like I probably have, Mr. Fix, I'll go ahead and send it to you. It looks like I have your email here, so I may go ahead and send it direct.
Yeah, just
Yeah.
in case I have a card in case you want to spell.
Okay. Yeah, sure, that helps. Thank you. So I think that's it. Do either of the parties have any procedural questions on that? Okay. We will move to the final item on the agenda. This is a special permit. This is for the Franklin County Historical Society Museum Annex. This is special permit 2019-002.
Yes, Madam Examiner, this is unusual. When the application was first submitted, the Planning Commission was in charge of a recommendation on special permits that was later submitted after their recommendation to the City Council for an official decision. When this application was submitted, there were questions on the site design. It was continued, I believe, 3, perhaps 4 separate times at the Planning Commission level. And in the interim, we switched from a Planning Commission style of land use decision making for special and conditional use permits to you, the hearing examiner. In checking with our city attorney, we were advised that the due process was certainly afforded the applicant through the 3 or 4 public hearings. The Planning Commission did make a recommendation of approval. The applicant, during the time that it was being postponed several times for additional site information, was successful in contacting with the pharmaceutical chain directly south of the proposal to use their parking area for additional parking, which allowed their site to be used in a much more efficient and neighborhood-friendly way in terms of site design and proximity of the buildings to the street. So the staff recommendation is simply that you consider the Planning Commission's recommendation and the findings and arrive at your decision. I would like to point out that The staff report that was distributed to you earlier does contain 3 errors, and if you can leave the record open, well, actually, there's no, if you can leave, if we can send you the revised staff report that indicates that the application has received a determination of non-significance, that public notice of the hearing was provided to property owners as required by the Pasco Municipal Code. And we would recommend that you consider the Planning Commission's recommendation for approval.
Okay, I think I don't think I received a copy of the planning commission recommendation, so perhaps, yeah, I have the, this staff report, here, and then I have attached the annex site plan, and then there are there's a couple pictures, there's an aerial photograph, and then, some elevations, but I don't think I have the planning commission recommendation.
Okay.
So if you can, but that's easy. If you
It
can
is,
just attach that to their, it can accompany the revised staff report, that would be helpful. And it sounds like to meet the parking requirements, they would, that they're using the adjacent parking lot. I don't know if there needs to be anything more specific in the conditions, on that. There is condition 7, proposed condition 7, looks like it addresses that. I was wondering about the wording on that, because certain, some wording, I mean, it's fine to use. I mean, I've seen other scenarios where adjacent property is used to meet parking requirements. And it sounds like that's the intent here, and it would just be up to the applicant to secure that, as that Rite Aid's not before, a party to the permit, so it'd be up to the applicant to secure all that. And I had a clarification question on the annex address. So is it actually all 3, 419, 421, 425? Is that how I refer to it, as the location, or are they consolidated at this point?
No, I think that the addresses you just recited would be applicable in this case.
All 3 of them? Okay. All right. And there's something in the staff report about the appearance of the structure or in terms of compatibility. Are those still concerns? And there were some renderings here that were provided, which look like it sounds like the intent is to develop the annex in a way which is consistent with the historical building, the museum there. And as I mentioned earlier, I did drive by this site along with the others, and so I'm familiar with what the existing structure looks like.
Yes.
So
yes, that is the intent, and I think that's fully the intent of the museum.
okay, and so does that address then the concern that was outlined in the staff report?
It does.
Okay, all right. Those were all the questions I had. Anything further?
No.
Okay. At this point, is the applicant here? Would you like to step forward? Thank you for waiting through the other items.
Thank you, Madam Examiner. My name is Richard Shireman, spelled Scheuerman.
And you swear to tell the truth under penalty of perjury under the laws of the state of Washington?
I do.
Thank you. Do you have anything that you want to add? It sounds like you've already been through some public hearings on this. And I'll begin it. I haven't reviewed their recommendation or the recommendation of the Planning Commission, but I'll take a look at that when it comes in. Is there anything that you wanted to add? Any comments that you have?
Just to reaffirm, as our helpful staff with Mr. Adams and Mr. White have shared, that we do intend to construct consistent with the architectural design of the historic site building that we presently
That's what it looked like from the renderings that I
Right.
saw in the packet that was provided. So
Yeah, and certainly have worked hard with them to assure that parking would be adequate for the needs we intend.
okay.
Grateful for consideration.
Thank you. I don't have any questions for you. It seems relatively straightforward, and it seems like a fair amount of work has gone into this already. So thank you. So anything else from the planning department? Oh, actually, wait. There's no one here, but just for the record, is there anyone from the public who wishes to provide testimony on this proposal? Let the record reflect there is not anyone here who wishes to provide testimony. All right. Now, anything further from the planning department? Okay. A decision on this will be out. 10 business days from when I receive the materials. How long should we keep the record open for that? Friday? Or
Just through Friday would
just
be
through Friday?
fine,
Okay,
yes.
so 10 business days from close of business on Friday, although this seems at this point, given the process it's been through, fairly straightforward. So, thank you. Anything else that I need to address before we close the hearing? Nope. Okay, we are adjourned. Thank you all.